Hello everyone, this is Urvashi Chauhan. Welcome back to another episode of Courts Today by Livelaw, where we bring you the latest developments from all courts across India. Let us start. Lawyer strikes, though common in our country, can have several adverse impacts on the legal system and administration of justice and society as a whole. While strikes may be a means for lawyers to protest or demand changes in their working conditions, they can disrupt the normal functioning of the legal process in various ways. The Indian judiciary is already flooded with volumes of cases. The abstinence of work only worsens the situation and affects the speedy justice process. The Rajasthan High Court Bar Association at Jaipur bench has once again attracted the indignation of Supreme Court for indulging in boycott. A bench comprising Justices Abhay S. Oak and Pankaj Mittal was hearing a special leave petition against an adverse order passed by the High Court due to non-appearance of advocates due to lawyers' strike. Criticizing the association's conduct, the Supreme Court issued notice to the association as well as the Bar Council of India. This matter will now be taken up on 3rd November. Let me tell you here, back in 2021, Rajasthan High Court Bar Association Jaipur had tendered an unconditional apology to the Supreme Court with respect to the contempt proceedings which were initiated against them for boycotting a bench of the High Court as part of a strike. The association at that time had undertaken to not indulge in court boycotts in future. Also, in April this year, the Supreme Court had directed all high courts to constitute grievance redressal cells through which the advocates can raise their issues without resorting to strikes. In an important update, the Madras High Court today dismissed the appeals preferred by 126 forest officials, 84 police personnel and 5 revenue officials against their convictions and sentence for various crimes that took place in Vachathi in Dharmapuri district of Tamil Nadu. For those of you who might not know, let me tell you, in June 1992, a team of 155 forest personnel, 108 policemen and 6 revenue officials entered the tribal-dominated village of Vachathi, searching for smuggled sandalwood and to gather information about Virappan, the infamous Indian bandit turned domestic terrorist. Under the pretext of search, it was alleged that the officials ransacked the villagers' property, destroyed houses, killed cattle, assaulted villagers, and even committed rape on the village women. CPIM State Secretary A. Nallasivan had filed a petition before the Supreme Court, which directed the High Court to hear the matter as early as possible. The High Court later ordered a CBI inquiry into the case. Out of the total 269 persons accused in the case, 54 died during the trial. Out of the remaining 126 forest personnel, 84 policemen and 5 revenue officials were convicted. Now the appeal filed by them before the High Court has been dismissed. Justice P. Vel Murugan called for stringent action against the then district collector, district forest officer and the superintendent of police. The bench also directed the state to pay compensation of 10 lakh rupees each to the rape victims, of which 50% will be recovered from the accused. The court also directed the state to give suitable employment to the victims whose houses were destroyed by the officials. The next update is from Bombay High Court. The division bench of Justice Gautam Patel and Neela Gokhale was today hearing rejoinder arguments in a batch of petitions challenging the IT Amendment Rules 2023, which allow formation of a government fact-check unit, that is FCU, to identify fake or misleading news about business of the government. The petitions have been filed by comedian Kunal Kamra, the Editors Guild of India and Association of Indian Magazines. During the last hearing, Solicitor General Tushar Mehta, appearing for the Ministry of Electronics and Information Technology, clarified that content flagged by the government under the new rules would have to be taken down, or a disclaimer that is at their own risk would have to be added. Senior advocate Navroz Sirvai, appearing for the petitioners today, argued that in terms of the impugned rule, once something is identified by the FCU, the intermediary has no option but to pull down the content or lose the safe harbor. There is no obligation on the FCU to say why something is fake or misleading. Senior advocate Arvind Dattar said that when a national newspaper publishes something, the government cannot ask them to take down calling it fake. Then how could they ask the intermediary to do so? That when the government gets to decide fake, false and misleading, it gets unbridled power. He said that the impugned rule could not be read down, it had to be struck down, so that freedom of speech, which is the most cherished right, can be protected. The arguments in the matter have concluded and the judgment will be pronounced on 1st December. Stay tuned with us. The Andhra Pradesh High Court has issued contempt notices to all those who were allegedly involved in posting derogatory remarks against the judges who heard the pleas related to former Chief Minister Chandrababu Naidu in the skill development scam cases. The criminal contempt motion was moved by Advocate General and Senior Counsel Subramaniam Sriram. The comments were made against 3 judges, Judge B. Satya Venkata Hema Bindu, ACB cum Additional District Judge Vijayawada, who passed the remand order in the trial court remanding Naidu to the central jail. Justice K. Srinivasa Reddy, who dismissed the petition filed to quash the FIR against Naidu, and Justice K. Suresh Reddy, before whom an anticipatory bail was filed by Naidu pertaining to another scam. The heinous remarks made against the judges on various social media platforms such as YouTube, Facebook, X, etc. allege that the orders were passed under the influence of Y.S. Jagan Mohan Reddy, the Chief Minister of Andhra Pradesh. In some, even death threats were made. The contempt plea states that such media interactions and television interviews as well as the posts on various social media scandalize the court and also tend to lower the dignity of judiciary in the eyes of the public. The matter will be taken up again next month. Stay tuned. In another update, the Allahabad High Court has stayed the demolition drive being carried out by Agra's local authority on a land claimed by Radha Swami Satsang Sabha, which is a religious and charitable society headquartered in Dayal Bagh. The society approached the High Court stating it received 2 notices from Tehsildar dated 14th and 15th September, requiring it to show cause as to why its construction over the disputed land should not be removed. Allegedly next day, the authorities began demolishing the gate and boundary walls erected by the society even before passing demolition orders. Petitioner also contended that 2 properties over which demolition had been carried out were protected by interim orders passed by the Allahabad High Court in separate proceedings. Justice Manish Kumar Nigam stayed the demolition and has directed both the parties to maintain status quo till the next date of listing. The National Human Rights Commission has issued an advisory to the central and state governments and administrations of union territories to ensure the welfare of transgender persons. The advisory has been prepared after wide discussions with various stakeholders and its core group members on LGBT issues. The advisory mainly highlights 6 key areas for action by the center states and UT administrations to ensure transgender persons get access to education, healthcare, employment, inclusivity, welfare, and grievance redressal. The Commission has asked for the implementation of its recommendations in letter and spirit and has sought an action taken report within 2 months. To read in detail about the recommendations made, you can visit livelaw.in. In the last update for today, the Delhi High Court has constituted a 7-member committee to streamline the process of availing free medical treatment under various government schemes in hospitals in the national capital. A division bench of Chief Justice Satish Chandra Sharma and Justice Sanjeev Narula said that the committee will give recommendations for elevating and curing the defects in the current system to avail financial assistance. The court observed that the procedure required for availing free medical treatment must be streamlined, including various surgeries as well as surgeries for implants. That the hospitals in Delhi must maintain a dynamic information list of drugs, implants, and devices on the website of the concerned departments, which may be revised frequently so that persons seeking treatment are aware of the availability in real time. And that the procedure for procuring financial assistance under different schemes must be made less cumbersome. The court said that the committee may suggest specific methodology under which patients belonging to economically weaker sections of the society may continue to receive benefits of treatment till the assistance is finally disbursed. The bench has asked the committee to furnish a report with its recommendations before 16th November, that is the next date of hearing. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.